for the Board of County Commissioners meeting to reconvene. We're at County Attorney Matters, and next up is an interlocal agreement with the City of Sebastian regarding the Fire Marshal Services. Mr. DeBrawl.
Nope, this will be Mr.
Oh, you're all prepared. I thought it was going to be for you.
Nope. Thank you very much.
Okay, Mr. Engel.
Good afternoon. Pursuant to the board's direction and authorization, county staff has negotiated an interlocal agreement with the City of Sebastian regarding fire marshal services. Under the proposed ILA, except for county-owned, occupied, or leased buildings, the city will perform fire safety plan review and inspection services within the city. The city also will be responsible for post-CO inspections and also special events. The ILA includes insurance and indemnification provisions protecting the county, and also newly hired individuals providing fire-related services will need to have 5 years of experience, just like our own employees would. The ILA will be for 10 years with an automatic 10-year renewal provision. Although not in the ILA, during the first 6 months, the Emergency Services District will be kind of shadowing city employees, assisting them in a smooth transition. I have sent a copy of the proposed ILA to Fellsmere to keep them in the loop, and would hope to work with them in bringing them to sign such an agreement if it was so the will of the board. And with that, the County Attorney's Office recommends approval of the proposed ILA and available for any questions. Thank you.
Thank you. Commissioners, any questions of Mr. Engel?
No question. Second.
We have a motion to approve by Commissioner Adams, second by Commissioner Zork. Anybody from the public wish to speak on this item? If not, all in favor?
Aye.
Any dissenting? Aye. Passes 3-1. Solari dissenting. Flesher absent.
Thank you very much.
You're welcome. Thank you. Move on to acquisition of right-of-way parcel 102, Phase 2 of 66th Avenue, improvements for Harris Grove, 61st Street, and 66th Avenue. Mr. DeBrawl.
Thank you, Commissioner Solari, Chairman Solari. Bill DeBrawl on behalf of the County Attorney's Office. Today we have for consideration purchase of a 3.75 acre parcel of right-of-way from Harris Groves. Harris Groves is a partnership made up of family members that has owned this property since 1983. It's about a quarter-mile frontage south of 61st Street along 66th Avenue. It's zoned A1 agricultural, 1 unit up to 5 acres. Used to be as you might guess, Harris Groves used to have citrus on the location. It is now since switched and is now a cattle operation still run by the family. There are no improvements to the property except for fencing. Like I said, it's about a quarter-mile of fencing, and then there's a path, a 2-trail dirt road on the inside of the fencing that would be affected by the area of take. The approximate percentage is about 10%, going in the 156 feet as we have been requiring, leaving a remainder parcel of about 34 acres. Historically, back in 2008, the board extended an unconditional offer to Harris Groves in the amount of $30,000 per acre for the property, a little bit better than that, about $114,000 for the property. And it would be severance damages in the amount of $15,000 plus an incentive for purchase, bringing the total offer to $148,350. This was back in 2008. We conducted a pre-suit mediation conference in July of this year. Mr. Spirica and I were present on behalf of the county. Mr. Brennan was the mediator. The Harris Groves folks were there with Mr. and Mrs. Groves, Mr. and Mrs. Harris, with their 2 sons that are the other 2 stakeholders in the partnership. We had assigned a value of $85,000 to the right-of-way, which you can see here, and their appraiser valued the property at $646,000. We agreed on following to present to the board for consideration and hopeful approval. We used the Central Groves purchase price of $35,250 per acre to arrive at about $132,190 for the property. The severance damages in this instance, we estimated at 5% or $59,500 damages to the remainder parcel, and the cost of removal and replacement of the quarter-mile of fence and relocation of the dirt road that's there, the flattened-out dirt road, at $27,000, bringing the entire, bringing the total cash to the Harris Groves of $218,500. Since it was citrus, it is furrowed, and the increased price to not only remove the fence but also to recreate the road would necessitate additional grading and earthwork there, and it is a fairly significant piece that it's at the quarter-mile post there. So with attorney's fees of $44,022 and costs of $24,230, the total acquisition price is $286,752. Of course, as I said before, cost avoidance is pretty much the name of the game in pre-acquisition status. There is no other property that's being given to Harris Groves, nor did county staff consider purchasing the entire 37-acre parcel, feeling it was much too big. So staff's recommendation is to go ahead and approve the purchase price at $218,500. Go ahead and approve the costs and the attorney's fees, bringing the total acquisition to $286,752. The other things that were included in there would be a concrete driveway that would intersect with the new pavement, starting out at 14 feet and flaring out to 36 to allow different types of cattle trucks to get in there. And the county would not oppose placing a culvert on 61st Street for access to the property. And if there are any questions, I'd be happy to try and answer them for you.
Any
Thank you.
questions for Mr. DeBrawl? Commissioner Adams?
Oh, no, I was waiting
Oh.
for Commissioner O'Brien. I figured this is his grand
I don't think he has any questions.
Well,
I have a couple diatribes, but there is one
Excellent,
question.
good.
There's one question.
Wait.
Bill, when we get this appraisal from the other side, do we get a copy of that appraisal?
Yes.
Okay, 'cause I'd like to look at that, because $646,000 is $172,267 per acre for pasture, and you can't run enough cows to get that valuation. I'm sorry. This, and commissioners, I say this every time, but we're seeing this creep and creep and creep. And $172,000 per acre for pasture land is, to me, it's embarrassing that we're even thinking about this number, quite frankly. So the total purchase price is coming out to $76,500 an acre, again, for pasture land. That's not including the cost to build the driveway, the culvert cost, all those other costs. And again, we're seeing this creep, and I'm getting embarrassed by these numbers we're having to deal with here. I would like to make a motion that we reject this settlement. We offer the Harrises the original unconditional offer of $148,000, and we give them 7 days to take it. And if they don't take it, we pull it, and then we move on to something different.
Is there a second? Motion fails for lack of a second. But Commissioner, I think, quite seriously, if, think about it over the next couple of weeks, but if you want to have a special call meeting and actually discuss right away and values and stuff like that, so we can do it in a more orderly fashion, I would certainly consider that. I think it's a worthwhile discussion, but I don't want to do it with one item without really thinking what the full repercussions are.
Would you,
But I mean, I
would you
feel-
be supportive of tabling this for a couple weeks till we have that meeting?
Not this one, because we have a whole slew of them that are going to be coming up. I just as soon do this one and use this as a good example. But I mean, I feel about this, I feel about septic to sewer the same way you feel about this. And it warrants, both of the issues warrant an actual cost-benefit study. So you think about it, and when I get back from Colorado,
I won't make it a special call, I'll just put it as an agenda item.
but I think it's the type of thing we're going to have to, well, on the agenda item, we're going to have to give some direction to staff, and staff is going to have to take some time to actually
Yeah, okay.
put some figures
I'm
together.
good
and-
with that.
Okay. So the first motion fails for lack of a second. Is there anybody else wants to try something?
I'll move approval, but just let me say I would support having some type of deeper discussion on how we deal with these in the future.
And I'll second that.
So a motion by Commissioner Adams, seconded by Commissioner Zork. Anybody from the public wish to speak on this item? All in favor? Aye. Any opposed?
Nay.
Motion passes 3-1. Commissioner O'Brien dissenting and Commissioner Fleischer absent.
Thank you.
Thank you, Mr. DeBrawl. With that, we will move on to the vaping update. Mr. Reingold.
Thank you very much. Board of County Commissioners has tasked the County Attorney's Office with researching ways to regulate vaping. Under state law, retailers of vaping products are not required to obtain a tobacco products dealer permit from the state. They're also not subject to an inspection without warrant, which is also something that tobacco products dealers are subject to. And finally, manufacturers and distributors are not required to obtain a permit from the state. Last year, the Florida legislature had considered House Bill 7119, which would have actually increased the minimum age for all tobacco products, including nicotine devices, to 21. The bill did not pass. And I want to note that we do have local regulations regarding vaping, which impose the same merchandising requirements on nicotine delivery devices as we do for other tobacco-style devices like cigarettes. Alachua County has earlier this year adopted an ordinance which increased the age for purchasing of tobacco and e-cigarettes to 21. They also established an annual license for those selling tobacco and e-cigarette products within Alachua County. So the county attorney's office, after having done the research of what some other counties are doing, what the state's been examining but did not get passed, county attorney's office now is just seeking guidance from the board as to how it wishes to move forward with vaping regulations. And with that, I turn it back over to the chair.
Thank you very much.
Mr. Chairman.
Commissioner Zork.
Yes, thank you. Dylan, I think the Bill 7119 had a lot of things in it that were probably pushing things a bit too far and kind of got away maybe from its core objectives. And currently you mentioned that we do have a ordinance on merchandising. How does somebody file a complaint under that, and who responds, and what's the ramifications?
I would imagine that it would be sort of a code enforcement item. Essentially, someone's violating the code, file a code complaint, and we would process it accordingly.
Okay. And in looking around, obviously the Alachua had some good things in it, but I think some things that made it probably not as palatable for our area. On the enforcement side, I would probably guess that code enforcement has not had any complaints, but Roland's not here at the moment, but I'm just going to take a stab at that we probably have not fielded any complaints. So there's we can't make our rule that if you want to sell product A, it's a combination license, it's vaping and cigarettes, and to get that, then they have to also have the cigarette license, which then brings in the state's enforcement side.
One of the notes I had in my memo, I didn't go into detail about this particular issue in the discussion I had, was that the board could consider adopting a local licensing program for tobacco products, including nicotine devices. Basically, I think one of the issues that it brought up at the last meeting was, can we adopt a requirement that they obtain the state's license? And my analysis was, I think we could. I'm just not sure what would then happen if they were in violation of their state license, if they weren't doing well, I guess they wouldn't be in violation of their state license because the state wouldn't be coming in to enforce an issue that they didn't feel was in violation of their license. The board could direct code enforcement to get them for violating what is our ordinance requirement.
Right, and I know our code enforcement folks are stretched, they're pretty busy all the time, and to add this to their plate obviously wasn't my goal, trying to have a way to have the traditional state enforcement of cigarette monitoring, sales, merchandising. So if we did modify our licensing requirement, that kind of treated them both the same, that you got a vaping or cigarette license, the same type, that would then require them to file with the state. The state hypothetically could come in and say, we don't regulate this side, that's a local issue, and then they could hypothetically walk out the door and say, there's nothing here we can do.
Yeah, arguably, I mean, I would assume they would get a complaint, the state would get a complaint concerning some violation of Chapter 569, and then the state would inspect the issue. If they're not selling anything that's regulated under 569, then I would assume exactly what you were saying is the state would just turn around and walk out.
Okay.
Well, from looking at this, it seems to me that what we're talking, the issue is not cigarettes or vaping, it's the chemicals that are bad for you in there, so it's nicotine.
Right.
So the state should grow up and realize that the problem is nicotine. They already have something on the books, and they ought to just change it to refer to the actual problem rather than the vehicle for the problem.
Right.
So with that, I think it'd be perfectly appropriate to make it a legislative priority to let the Florida legislature enact legislation that would require that. And I also think we then avoid the problem of local governments interfering with things that could be statewide issues and further blurring the lines between local government functions and state functions. So anyway.
This would be a good one for the upcoming policy conference to see. I'm sure we're not.
It's all over the state, I'm sure, so be happy to entertain a motion to that effect.
And I think there may be some people here that want to speak today that have been here since this morning, but in the process, I will make a motion that we look at adding the nicotine delivery to our legislative priority list to work with FAC and other interested parties to try to work with the legislature in bringing that under state control.
I'll second that motion and ask if there's anybody in the public who wishes to speak on this item. Come on up, please. Name and address for the record, please.
Good afternoon. My name is Kylie Savoy, 1040 10th Avenue. I am the community health advocate for the Quit Doc Foundation, and I'm a tobacco-free partnership member. I'd like to thank Dylan for his presentation, but I do want to report on some statistics and just the benefits of a tobacco retail license. So in 2012, the Surgeon General report came out that nearly 90% of smokers start before the age of 18, and 99% begin before the age of 26. Today in Indian River County, 20% of youth report using an electronic cigarette device. So that means statistically, 90% of those youth are likely to have a lifelong addiction to nicotine, and with various and unknown health consequences of these products. Retail at the point of sale has been proven to be the main cause of tobacco youth exposure and enabling them to form this habit. A tobacco retail license provides local control over these products without having to enact statewide legislation that tobacco can label as anti-business. By enacting a tobacco retail license, this county will be taking steps to limit negative public health consequences and youth access to tobacco. In addition, it can expand health equity by counteracting the campaigns of the tobacco industry that often affect our vulnerable populations. The TRL can be a model for implementing other tobacco control policies, while annual fees produce a self-sustaining program to permit regular enforcement. By pursuing a tobacco retail license, Indian River County will have more control over how tobacco and nicotine products are sold. As a result, youth access and exposure to tobacco and nicotine products at the retail point of sale will decrease, successfully counteracting health equity and social justice issues exacerbated by tobacco industry's marketing tactics. And I am here for questions if you have any. Thank you.
Thank you. Anybody else from the public?
Wait.
Yes, sir.
Pedro Burnaby, 1817 41st Avenue, Vero Beach, Florida. 19-year Indian River County resident. I am the executive director of Phoenix Rising Wellness Center. It's a substance abuse treatment facility here in the county. I've been working in substance abuse for 5 years. 90+% of my clients that come through for addictions have smoked or used a nicotine product while they're in their teens. It's a big problem. It's a huge problem. I did substance abuse prevention at the high school level a few years ago, and talking to the students, it has become a problem, and that can also lead to addictions of all other harder drugs. I think we have somebody speaking on opiates later on, in which is, I think, it's a crisis that we are facing today. It is very important for us to take a step back and look at what we can do as citizens and residents of this county, and that you guys now have the power to be ahead of this instead of following the rest of the state. I think that right now we can set up precedents of how we can, other counties can look at this and, be in the forefront of this rather than behind it. That's all I have to say.
Thank you. Want to speak to?
My
Name and
name
address for the
is-
record, please.
I'm sorry?
Name and address for the record.
Yes, my name is Marie Wygonick Blanchard at 1425 22nd Avenue since 1968. And I work for the Florida Department of Health, but I am also a member of the Tobacco-Free Partnership here. And one of the hats that I wear is I'm the advisor for SWAT, which is Students Working Against Tobacco in several of the schools here in the county. And I work directly with the kids, and I hear what the kids are saying about vaping, and it alarms me. It bothers me. It really worries me. It makes me sad because these are our kids. I strongly support keeping those dangerous and addictive nicotine products out of the hands of our youth, of our kids in our county. Earlier this year, Alachua County, the Board of County Commissioners did approve an ordinance for the local licensing program. And I support, that if you use Alachua County as a template for establishing controls in our county, because it's the consumer protection is a key. Limiting access to our kids, to your kids, to my kids, to our kids, to Indian River County kids is so important. And the kids are our future. So I speak for the kids. We need to keep we need to keep nicotine out of the hands of our kids, and we need to address it as a nicotine issue and not just a tobacco issue. And yes, we do need to establish some sort of controls here for our kids, for our future. Thank you.
Thank you. Anyone else from the public on this issue? So we have a motion and a second to go with the legislative priority. Any other questions?
And
comments?
I'll say we'll see how this kind of pans out. If we see that we need to explore some other option, that the lobby in the state is just too powerful to get any change made, then we can revisit this. But since we do have a meeting coming up in the next 30 days, I believe, where we can see what other approaches we're working on as Florida Association of Counties to see what change we might be able to invoke this session.
Very good. All in favor? Aye. Any opposed? Motion passes 4-0. Commissioner Fletcher absent.
Thank you very much.
Thank you. Move on to opioid litigation update. Mr. Rangel.
Thank you very much. In March of 2018, the Board of County Commissioners had directed the County Attorney's Office to monitor the opioid litigation issue. On a federal level, the cases have been consolidated into one multi-district litigation in the Northern District of Ohio. Right now, there are approximately 1,800 cases that are combined before Judge Polster. The first set of cases is actually set to go to trial in October. In June, a proposed plan for a global settlement was announced by the plaintiffs' attorneys. The plan calls for local governments to receive compensation based upon three different factors: the number of drugs shipped to that jurisdiction, the number of opioid deaths or overdose deaths within that jurisdiction, and then finally the number of people addicted in that jurisdiction. Plan has different voting classes. There was a hearing on the plan last week on August 6th. And although the judge did not rule at that time, what I've heard is that the indications are that the judge is supportive of a global plan, but we are still waiting for a ruling from the judge. I will note that the plan is opposed by some of the defendants and 39 states, including the state of Florida. Just wanted to note that several local governments in Florida had attempted to file cases in state court. Goals there by those local governments were to have basically the concept of, isn't it best to have your attorneys in your local courthouse in your hometown? I can tell you the city of Miami and Alachua County, both of those cases have been removed to federal court and then sent up to the Northern District of Ohio. I think that's pretty much how most, if not all, of the state cases have landed with regards to local governments here in Florida. Otherwise, on a state court front, the state of Oklahoma trial is actually completed. They had a trial against Johnson & Johnson, which is now done, and we are waiting for the court in that decision to make a decision and a ruling, which we believe will happen by the end of this month. I know there are some attorneys here today who wish to make presentations to the board on this issue. I have no particular recommendation to this issue, just simply want to make sure that I provide an update to the board, allow an opportunity for those to speak on the issue. And with that, I turn it back over to the chair.
Thank you. Commissioners, any questions for Mr. Reingold? There being none, I'll ask if anybody from the public wishes to speak on this item. Welcome. Name and address for the record, please.
Thank you, Mr. Chair. Attorney Cynthia Angeles. I have an address in Port St. Lucie, is that sufficient for you, sir?
Yes.
Thank you. I'm here with Attorney Michael Kahn. Mr. Kahn and I are involved in representing about 14 counties and 10 cities. For me, Indian River County, it was important for me to be able to address this commission. As some of you may remember, I was a circuit court judge here for over a decade and have a unique perspective on this epidemic, having sat and watched the lives that it destroyed in our circuit for a number of years. We do represent St. Lucie County, the city of Port St. Lucie, the city of Fort Pierce, the St. Lucie Fire District, and I believe it's important for the commission to be aware of what the case is about and consider joining this federal lawsuit. The Attorney General's report of this year states that the opioid epidemic is the leading cause of death in the United States, and that Florida has the highest number of deaths in the United States due to the epidemic. The report states that Florida physicians dispense the highest quantities of oxycodone in the country. And just looking at a few statistics locally, I would note that in 2018, Indian River County had 775 new drug charge arrests. And based on the drugs identified in deceased persons by the Florida medical examiners, oxycodone had a greater number of deaths in Indian River County on a population basis per occurrence than both Broward and Miami-Dade. And I think that, you know, Mr. Kahn's going to address the commission on the substance of the litigation, but I noticed that the judge had a few quotes, Judge Polster, who's been presiding over this case. And the judge said himself, and it mirrors the way that I feel about this case, and you probably do too, the stakes are incredibly high. Any thinking person should feel terrible about the situation that we're in. He said that the judicial branch typically doesn't fix social problems, but it seems the most human thing to do. And the situation that we found ourselves in this country since 2005, when OxyContin was first manufactured, is that it took over our country like a storm and addicted a great number of our population. While there is a purpose for the use of that drug and others, there was a conscientious effort on the part of the manufacturers and the distributors, for lack of a better term, to pull the wool over the eyes of the American public that resulted in the statistics that I've just said to you. Fortunately, this particular case and this lawsuit is the only thing that has brought about any change in this epidemic. The numbers are going down. Many of the individuals who are parts of the families that started these companies that manufactured these drugs have actually been indicted criminally. So it is making a difference, and we're hopeful that Indian River County will consider joining the case, and Mike will tell you the details of the lawsuit unless you have any other questions for me.
Thank you.
Thank
Any
you.
questions for?
Thank you,
Ms.
Commissioner.
Angeles?
Thank you, Mr. Chair.
Thank you.
Mr. Chair, members of the commission, and I thank Judge Angelos for joining our group. The status of the lawsuit, really, right now, first of all, we have filed on behalf of a total of 16 counties now and 10 cities, a 12-count lawsuit. That lawsuit is against manufacturers. It is against distributors of opioids. I want to echo something that Judge Angelos said. This is not a rush to judgment. There is a place for opioids in today's society. They reduce pain. They help people. And this is a very important point to make. And we must always make that point. The status of the lawsuit is, as Mr. Reingold suggested and Judge Angelos. In October, the first cases will go to trial. This August the 6th, there was a hearing, and in all probability, there's going to be a negotiating class that is created, which we hope that Indian River County will partake of. Our fee agreement is classic. If we don't gain anything for you, monetary relief, then you don't pay us any money. It's really literally a no-risk situation for the county. But the bottom line is that I'm here to answer any questions that you may have, and we hope you will consider, as Judge Angelos has said, joining the effort. But back to the beginning, there is a place for opioids in today's society, and we don't want to overlook that when we talk about the people, the manufacturers and defendants and the distributors who have abused the privilege and the benefits of such medicine. And our fee agreement, and I had previously distributed a booklet describing our group and the fee agreement. It is classically, we will file a complaint if retained within about a week of being retained for Indian River County. And upon that filing, if we gain monetary relief for Indian River County, the county would owe us 20%. The fee agreements are, the fee is in page 23. One last thing I want to mention about our group, it's been a privilege for me to work with this group. We represent about 4.5 million people in the state of Florida. One of our members is particularly special. His name is Peter Weinberger. His biography is on page 7 of the booklet. He is one of 3 lawyers selected nationwide who are co-plaintiff liaisons. He talks every day, and he can, by law, to Judge Polster. So we're privileged to have him, and now I'm opening it up to any questions that I can answer. And I appreciate Mr. Chair, and I hope I have presented adequately before the commission.
Thank you very much. Any questions for Mr. Khan? And for myself, I thank you for coming. I mean, if we were to move forward with something like this, we'd actually probably have to have a request for proposal. But for myself, I did meet with you and got a lot of information from you, but actually the information, did tell me what we already knew, that opioids can be bad, but there is nothing that I saw in there that could direct us in the formulation of policy going forward. And I actually did read the book, Dope Sick, but again, it provided nothing in terms of policy. And towards the end, the author blames the problem on pharmaceutical companies generally, the billionaire class holding sway in Washington, and capitalism. So I don't really think that she provided anything in the way of policy. So with that, I mean, I think that there's plenty of people involved in the suit, including the state of Florida right now, and that's probably sufficient for me, but I'd be happy to hear from any other commissioners.
Just a question for Dylan. So Dylan, on this, the global settlement thing, it sounds like if the judge approves that, then we're automatically in unless we opt out. Did I read that correct?
Yeah, we would be in unless we opt out. Now, there's a voting scheme that needs to happen. There are different classes and a certain number, all the classes need to be on board. But basically that would create the negotiating class, and we would be a part of it unless we opted out.
Okay. And the judge had that hearing a week ago, but he hasn't released his ruling yet.
I looked this morning, right before the board meeting started, and I did not see any news updates on whether there had been a ruling.
Okay. So would we be better off just waiting until that ruling and then deciding what our next step would be after that?
I'm not aware of a rush right now on needing to take any action today.
Okay. Thank you.
And I will certainly, as I did with this item, keep the board informed of any other issues. And if it's necessary, I'll make sure to send emails to the full board just to make sure you're aware of any changes. For instance, if there's a ruling that comes out, Friday this week, I'll make sure that I email everybody to let you know.
So it sounds like the best path forward right now is for asking the county attorney to just keep us informed of what's going on with the case. Basic consensus?
Yeah, I think I'm good with that. I appreciate Judge Angelos and Mr. Khan coming back again, but I'm not feeling any urgency either at this point.
Thank you very much.
Thank you for coming, yeah.
We now move on to special districts and boards, emergency service.
I'm going to stop you right there, Chair, if it's okay. The board had added Agriculture Advisory Committee appointment.
I'd like to move approval.
Second?
Motion from Commissioner Adams, second by Commissioner Zork. Any comments from the public? All in favor?
Aye.
Any opposed? Passes 4-0.
Thank you, and I'll clarify that was to add Anna Kirkland because my board memo does not necessarily have a recommendation.
Thank you very much.
Thank you.
Mr. Chairman, I move approval of the Emergency Services District minutes of May 7, May 21, and, oh, we already did this. That's right.
We did that with Solid Waste Disposal District. No, excuse me.
Yeah.
Yep, Solid Waste Disposal District, final pay to Geosyntec for work authorization number CCNA 2018. Good. Welcome back, Mr. Burke.
I'll move staff recommendation.
Motion by Commissioner O'Brien, second by Commissioner Adams. Anybody from the public wish to comment on this? All in favor?
Aye.
Any opposed? Passes 4-0. Commissioner Fleischer absent. Final pay to CDM Smith CCNA 2018 work order number 2, contamination evaluation plan implementation.
Move staff recommendation.
Motion from Commissioner O'Brien, second by Commissioner Adams. Anybody from the public wish to comment on this item? All in favor?
Aye.
Any opposed? Passes 4-0. Commissioner Fleischer absent. Moving on to update on potential transition to mandatory garbage collection. And Himanshu, are you going to lead us here? Mr. Burke.
So again, Vincent Burke, Director of Utility Services. To my left, Himanshu Mehta is Managing Director of the Solid Waste Disposal District. The board may recall that it took a pretty substantial step in trying to look at mandatory collection for garbage in the unincorporated portion of the county and portions of those areas outside the urban service area. That was on July 17th. So as a placeholder, the board here directed staff to work with the property appraiser's office to put a $51 or a 6-month fee on those properties that would be charged inside the urban service area and TND, or traditional neighborhood developments. Staff came back at a special call meeting on July 23rd and clarified that position with respect to the properties inside the urban service area or outside the urban service area. So I just wanted to let you know that since that time, we have met with Waste Management. We're going to go into some of the details, and we wanted to bring an update to the board. I note that this agenda was written just as an informational item only, just so that the board has up-to-date information prior to the 2 public hearings that are scheduled for September 11th and September 18th, where the decision will be made to either move forward with that proposed assessment or not. So without further ado, I'm going to turn over to Himanshu that's going to go through some of the details of how we got here. Thank you.
Good afternoon, Commissioners. Himanshu Mehta, Managing Director for Solid Waste Disposal District. So just right on the cover, the picture on the left is the actual picture. That's what's happening in the community. Residents are using their recycling cart for garbage service. And so kind of, the whole idea of sort of mandatory collection was to give these residents a garbage cart and have them hopefully do the right thing and put the garbage in a garbage cart. So with that, as Vinny kind of mentioned, just backing up a little bit, we became aware of this back in sort of April timeframe. We started auditing carts, started working with Republic Services, Tropical Recycling, Waste Management. But the issue kind of continues, and as of last month, we had about 51 waste management trucks, or about 300 tons of recyclables were dumped into the landfill. and a lot of the material is still, showing up as contaminated. So even though our auditing process, our code enforcement process is continuing, we're diverting these trucks from our MRF area so that they don't go to tropical recycling. I know the board has given them some relief on some of the contamination that's they've experienced in the past. Just kind of, the whole action plan that we came up with was to try to identify, educate, and enforce violations of the county code. That's section 20409, which A6, which states that not commingle garbage or yard trash with recyclables in a recycling container. And so, so far, we just got an email again with Waste Management. They have been assisting with tagging carts. Their drivers visually identify if there's a cart, recycling cart that has what suspect to be maybe garbage sticking outside of it. If they can see it, then they'll stop, tag that cart. And so, again, with efforts that staff has been made over the past few months, the email this morning, the total count from starting in June was about 847 carts have been tagged. There was a great effort in June, about 536 carts. It dropped down to about 256 in July, and so far in August, about 55 carts have been tagged. For yesterday, for example, 4 carts were tagged by Waste Management. We did do an education, approach. I think a lot of you probably saw these postcards that went out, over 71,000 cards. It resulted in a lot of phone calls. I think some positive phone calls. A lot of people didn't realize some of the things that they were doing wrong. They said, hey, how can I help? So, Sue received a lot of phone calls. We had a request for her to come out and do a lot of presentations in the community. So the articles that the press has been writing, all of this has been getting the right attention, if you will, for the folks that do care about preserving our recycling program. They're wanting to know, hey, what can they do to kind of help and do a better job? They certainly don't want to contribute to the problem. And then code enforcement, we've had over like 50 code warning notices, actual letters that have gone out, formal violation letters. There's been about 13 that have actually went to the code board agenda last month, and those we're working to identify if those people are actually going to be issued a request to show up to the board hearing this month. So that process is continuing, but it's several months, if you will, by the time that it's identified, a warning letter's gone out, and so on and so forth. And that kind of brings us to what Vinny just kind of mentioned, the board. The board kind of took a strong action, if you will, at the July 17th meeting, and unanimously voted to include 6 months of mandatory garbage collection on the 2019-20 trim notices for service to start on April 1, 2020. I think Vinny just confirmed that he received his trim notice yesterday. And so these trim notices are, started going out yesterday. We worked very hard with the property appraiser's office, our GIS department, to identify these parcels that would be inside the urban service area. And I'll show you a map in a second. So that, and then we had a special call meeting where we specifically sort of identified, that it would be the higher rate for unincorporated residents inside the urban service area and what we define as traditional neighborhoods, like Point West, for example. And so out of that effort, 36,960 residential parcels on their trim notices will have that higher 107.44 per WGU or $171.90 per ERU rate on those trim notices. Here's the map, and to kind of clarify, the areas in the red are basically areas inside the urban service area. And overall, that's about over 44,000 parcels. Now, a lot of them are multifamily, a lot of them are condos, and so on and so forth that have dumpster service. So we're not the red area does include those, and that's about 45,000 parcels, if you will. Out of that, it was a lot of effort using Waste Management's data on who are they providing carted service right now. And so out of that, about 37,000 parcels, if you will, were identified as receiving carted garbage service. And out of the data for Waste Management for June, we were actually kind of surprised that the subscription rate is about 73% from our numbers that we could tell. And that there would be an additional 10,000 new customers that would be receiving mandatory garbage collection service. What about the impact to the outside? So the outside area is the areas in the white. So it doesn't include any of the municipalities. So the areas in the white would be outside the urban service area, outside the traditional neighborhoods. And we've identified about 1,483 parcels, and out of that, about 389 or 26% currently receive carted garbage service. So they're on a voluntary basis. They're, the 389 folks that choose to have garbage service outside the urban service area. So it's not a big amount, but those are the residents, if you will, in the white areas. And again, the municipalities are in the gray. They're not impacted by the trim notice that went out for the higher mandatory collection. In terms of the rates, we did bring a CPI approval to you last month that had a universal or mandatory collection rate. We received a letter from Waste Management kind of correcting that. The calculated rate is $8.19 per month. And if you look at what the proposed rate starting October 1, it is $10.14 per month for that CPI approval. So it would actually be a 19% decrease to our residents inside the urban service area and the T&D areas if we went to a mandatory collection. Now, what happened here is in our discussion with Waste Management, they submitted a letter confirming the $8.19. However, they said that the rate would be about 43% higher for those residents living outside the urban service area. So that they proposed that the rate outside would go from the current, the proposed $10 to $14.54. So that was something very surprising to us. County attorneys looked at our contract agreement, and staff doesn't agree that the rate should increase for the residents outside the urban service area, that it should remain the current subscription rate. Further than that, we've received county administrator received an email on July 31 that Waste Management is making some additional requests. We all agree that 2015 transition was very challenging, very difficult. And I think Waste Management, in order to prepare for a repeat of something like that, they've asked to waive administrative charges for route deployment, missed pickups or complaints, or failure to repair, replace, or deliver carts. And the actual letter is in your agenda backup, but summarizing some of the other items, they wanted some relief on vehicle collection equipment and requirements, redefine some ancillary services, review the RFID and asset management requirements, and change from what's currently a sole option for the county to renew the 3 additional years. They want a mutual option for contract renewal. So these were kind of just a quick summary of some of the items that Waste Management asked. For us as staff, the biggest thing was the impact to the residents outside the urban service area. We feel that that's not fair, that they should somehow be penalized with a decision to go to mandatory. And we certainly, as staff, want to work with Waste Management. We feel that if there are some issues with trucks, for example, the CNG trucks, getting brand new trucks by April 1, if that's a difficult thing, that we certainly would be willing to work with them on that. But in terms of, we certainly don't want to plan for failure. We want to plan for success, and we wanted mandatory collection to be something that there would be a smooth transition on. So the ability to waive charges is something that staff didn't feel comfortable with either. Certainly, I'll if Jason or Vinny or Dylan want to add to that. But overall, to summarize, we just feel that there's a lack of cooperation from Waste Management, and so we're feeling that lack of that cooperation, we are considering that the SWIB board not consider implementing mandatory collection until the current contract expires on September 30, 2022. In order to continue to address single stream contamination, we feel that we've seen, for example, Orange County, they've hired outside services. They've actually have 2 full-time staff, some consultants, and a bunch of day laborers. They're going in communities, looking in the recycling carts, tagging the carts, but it is a costly effort to continue to put the troops on the ground, if you will, to kind of identify the contamination and try to address it through some sort of enforcement, education type of process. And then finally, we just need to ensure that Waste Management is adhering to the terms and conditions of our current franchise agreement in terms of helping address the contamination issue. With that, we'll answer any questions that you have.
I have one to start. If I just want to make sure that I understand you correctly. So if I understand it correctly, the contract anticipated that we might go to universal or mandatory pickup.
Correct.
And this was a bargain for agreed upon paragraph in the contract.
That's correct.
And we then went to Waste Management and said that we are going before the board to see if we're going to implement this already agreed upon contractual paragraph. And their response, Waste Management's response, was basically to use this as an opportunity to exact a pound of flesh from our citizens. I mean, to change, to add other clauses that weren't anticipated in the contract to their financial benefit.
Yes.
Correct? Okay, I just want to make sure.
Well,
I mean, the idea.
I differ on that, but I'll let you finish that.
You differ on that?
Well,
I'm asking staff right now, and so you can differ later, but right now, I'm trying to get staff's opinion. I mean, what I heard them say is that the cart for the outside customers went up 43%. Is that a response from Waste Management?
That was in the letter we received from Waste Management, yes.
And that they want us to now waive administrative charges, which we put in there initially to make sure that they performed in a certain way. That they want relief on equipment, which, again, was anticipated. If you go to mandatory pickup, you're going to need some more equipment. That we move from the sole option to a mutual option. So these are all changes. So now I'd be happy to see how you disagree with the idea that these were.
Well, in looking at, this is page 34 of Exhibit 1, which.
Right here.
We have that? Okay. So where does it address the rate structure outside the urban service area?
Why would they have to address it when we already have an agreed upon price in the contract?
Well, in the contract, this is the contract page.
Yes.
This is the submittal page of the RFP that the contract was developed from. And the print is very small, but I don't see an outside the urban service area price in the original RFP that was submitted.
Well, is there a price in the outside area that customers are paying today?
Yes.
Yes.
I'll make an attempt at that.
Okay.
And I'll allow Dylan to correct me if I go astray or if he needs to add anything else. Looking at the contract, provision 6.6 is provision for universal residential collection service. So I'd like to just read from the contract, just so the board has the information that staff is looking at and relying on to make this information. Provision for universal residential collection service. This is what's in there specifically for this, where we're considering going from subscription to universal, which we should call mandatory. I agree with the chairman on that, but it's called universal in the agreement. Should SWID decide to implement universal residential collection service in the urban service area of the solid waste franchise area, along with any participating municipality, franchisee shall honor the proposed universal rates provided in Exhibit 1, and it goes on to talk about CPI adjustments. So, if you go to Exhibit 1, and Scott, if you can pull that up just so that the board is looking, I think there it is. If it's Exhibit 1, collection service rates, it's got residential collection service, subscription service, which is what we have right now. The bottom line there, total subscription service was $968 in 2015. That with the CPI, it's what the 1014 is today. And then the next rate is residential collection service, universal service in urban service area, applicable only if SWID initiates universal collection. So this is what we believe is the universal rate. I think it's pretty clear. Total universal service in the USA, $773, which with CPI adjustments brings us to the $819 a month. If you scroll down, you can see that there's some commercial rates, but that's it. That's it for residential. There's no rate outside the urban service area. Staff believes that those folks in the outside the urban service area, they would still be subscription service. They would fall under the 968 or as adjusted 1014. I think that's pretty clear. Waste Management did go back to something from the RFP. If you'll recall, when we did the RFP, we had about, 27 different scenarios we were looking at, and they went to some document that they proposed that showed a higher rate that they've used to justify this $14 a month charge. It's not in the contract. It's not what was in the contract. The contract contemplated changing to this, specifically in the urban service area and not outside. There was no rate placed on this. Furthermore, from a policy standpoint, I don't know how we justify going to those 300 and some odd, almost 400 customers in the outside the urban service area and say, well, guess what, folks? Your rate's going from $10 a month to $14 a month. And they say, why? Well, because we're going to universal collection in the urban service area, and you're not in the urban service area, so your rate's going up 43%. Why does that happen? I can't explain why. I don't know how the cost would go up to Waste Management for servicing those areas just based on having more customers in the urban service area. I think if anything, it would go down. I certainly, and I think from a policy standpoint, I really don't want to put the board in the position of having to make that decision. The decision to potentially go to mandatory collection is something that is potentially politically unpopular with a portion of our community. So it would be a hard decision for the board to make, and piling this on top of that, along with some other things that I'm not going to get into just yet, is really unreasonable. But I don't see any $14 there that's in the contract. That's it. This is Exhibit 1. It's one page. Everything below this is commercial rates. It's roll-off containers and dumpsters. So I don't know how they're getting to $14 other than this RFP they had. Attorneys may disagree on this, but I think it's pretty clear there's not a higher rate contemplated in the agreement.
Okay, and then, so line 33, I see where they get it, because line 33 on page 3 of 7 has those rates. Now this was one of, a big RFP submitted document that then the contract was made from.
That's not part of the contract. It's a separate document.
So we can take, so the inside the urban service line, we agree, or is the number, let me get to the right chart. So if you go to the inside the urban service line number, that's the trued up, what was originally the 773 is now whatever it is with the CPI index.
819.
Right. So couldn't we not just do the inside the urban service area only, and there's 226 in the outside, and just leave those subscribers on whatever rate plan that they currently have?
That's what I would have thought that we would do.
But they're proposing something different.
They're proposing to jerk the price up 43% is what our staff said, and what I tried to make sure I understood correctly.
For the 200 and so.
For the 300 and some customers outside the urban service area. That's the issue that we have, and that Mr. Brown was trying to explain to us. He doesn't see the equity in us going to universal mandatory pickup inside the urban service area, while the people outside are now forced to pay 43% more. So, but for me, it's more than that, because not only did they try to adjust the price, but they tried to exact a lot of other conditions out of us, which have nothing to do with the price of it. You know, there could have been an argument that, if you change the way you're doing things, you could impact our per unit price for outside the urban service area, and that could have been part of a rational discussion. But that's not what the contract says and not what the exhibit says. But all these other provisions that they did is just using this as an opportunity to do something which I don't think was anticipated by the contract with both sides signed. So Mr. Burke.
I did want to make the board aware of one thing. The county has been very, I think, aggressive in trying to reach the state goal of 75%. This is what the big issue is. If you recall, I think the board is aware that we're at 66%. However, because we have not even met the 70%, we now have to prepare a plan to send to the DEP that explains what we're going to do to then get to 70 and then 75%. So it seems that part of this issue is what Himanshu started out with, which is to say those folks that are doing the wrong thing, out of like, say, 1,000 homes getting picked up, you might have 30 or 40 homes that are using the blue bins for garbage. It then defeats the purpose of us trying to be able to increase our recycling, reduce some of the material that's going into landfill, and ultimately now we are still having to send notice to the DEP with a report of how we're going to fix, obviously, the shortfall this year with the anticipation of going to 75% by next year.
Thank you.
I have a couple comments.
Commissioner Adams.
So, first of all, I think that this whole situation from Waste Management is very discouraging and somewhat ridiculous, to be quite honest with you. But moving beyond the contract issues, contamination oversight was a legislative priority from the haulers this year in the legislature, primarily driven by, I think Waste Management took a very big lead on getting contamination legislation passed, which ultimately didn't pass. But what they would like to have seen in that legislation was that contracts address contamination issues and how the municipalities or counties and the haulers work out those issues. So my understanding is we have a contract that speaks to how that's supposed to happen. We have in place exactly what Waste Management and the other haulers were trying to get passed legislatively. Yet, we're the ones that are going out and looking at the contamination and looking at the contamination issues. If you look at the numbers, 847 carts since June, I think is what you said, have been tagged. With the majority of those carts being tagged in June, when our staff was the one going out and looking at the contamination and trying to solve the problem. Since then, we've had maybe 100 tagged, and that's probably being generous. I guess in August we've had 5 or something like
55.
that. 50, just an insignificant number compared to 847. Since the drivers who don't get out of the truck, so the only way you can see if there's contamination is if it's hanging out of the cart, which most people are smart enough to smash it down and close the lid so they don't get caught, are the ones that are now looking for the contamination. I just don't see that as an effective method of dealing with it. And I don't think that it should be, if we have a contract that speaks to how we address contamination, then it should not be our staff that's going out and doing it, nor should it be us who are responsible for hiring a separate service and paying for that to go out and do something which we've apparently negotiated, you guys did this years ago, thankfully, in the contract that we currently have, which is, again, exactly what the haulers wanted to pass legislation to mandate that we already have. So we have it, and it should be enforced, and it should not be our job to do that. That's item 1. Item 2 is I continue to get complaints about the trucks driving up and down the dirt roads, whether it's in the county, outside the urban service area, or inside the urban service area in the cities and some of the county areas that have dirt roads. I see it when they drive past my house. I have trash collection, and obviously I have recycling. Because you guys have a schedule that the drivers must maintain, they are tearing up our dirt roads because they drive 1,000,000 miles an hour from one house to the neighbor's house and slam on their brakes. I don't see anybody looking at any kind of contamination when I drive around because they're going too fast to see it. So the road issue is still a problem with the trucks. I continue to field complaints about that. I've passed them on. They've been addressed from time to time, but that's an overall systemic issue that needs really to be addressed by Waste Management and how they schedule those trucks. I mean, if it's a dirt road, probably needs to give them a little bit more time to complete their route than a paved street because of the nature of the roads. So those are 2 issues that I have, and I could go on and on with the list of things that Waste Management has submitted, but, you know, we are either gonna have a collaborative partnership to try to address it, or we're not, and it seems to me like we're not, so I'm very frustrated and aggravated, to be quite frank with you.
Thank you.
Mr. Chairman, yeah, thank you. You know, what I find most amazing is about a month ago, I was at a backpack giveaway sponsored by Waste Management at Gifford Youth Achievement Center, and talked about our contamination problem with Waste Management staff, and their response was, oh yeah, we would love it if you guys went to mandatory. So here we are trying to take that step, and yet we're getting all this pushback from them. It would almost seem like this is a no-brainer because they're already driving the routes. They're just not picking up every house on that route. So there's no, I know back in 2015 when they first came in, there was a lot of issues. They didn't have the customer base from Republic and all these things. But right now, they're driving by every house inside the urban service area. They're just not picking up every house. So it seemed to be a no-brainer. They would want to add those 10,000 additional customers. And then we're going to do the billing for them. They don't even have to send a bill out anymore. We're going to collect it in the tax bill and pay them. You know, it's almost like we're putting this on a silver platter for them. Here's 10,000 more new customers. You're already driving by their house. Now you just got to stop and pick up the garbage, and we're going to collect the money for you. I mean, it just boggles the mind. But a question for Dylan, and the one thing is, you know, I guess if all 10,000 of those folks not getting curbside pickup called up tomorrow and said, hey, we want trash pickup starting next week, Waste Management would then have to come up with the trucks and do it, right? I mean, although wanting to work with them in a collaborative way, if they need a 6-month extension or something to get the trucks here to and the right age, you know, I'd be willing to work with them on that, okay? I understand that their contract says no, they have to provide them, and that's that. But if giving them 6 months to get new trucks here will get us there, then I'm willing to consider that. But not these other conditions they're trying to change. So Dylan, you know, just from a contract point of view, would we be able to say, hey, we want to start universal mandatory collection April 1st? The rate will be $8.19 for those people within urban service area. You're not going to change the rate, the approved rate for outside the urban service. That's still going to be, like if somebody from Blue Cypress Lake called up tomorrow and said, I want garbage pickup, they pay $10.14, right? So we're not changing that and say, okay, and we'll give you 6 months on the age of the vehicles to help you out. But the contract says you all need to do this. Aren't they contractually obligated to do just that? I mean,
That's my view of the contract. I mean, that's basically, as Jason read it, under 6.6, the SWID board makes the decision to go with mandatory recycling, I mean, mandatory collection of garbage, then that gets triggered. I mean, and as you were talking about, I've heard nothing but from staff of, we want to work with Waste Management if they need more time, if they may need an extra month, if they need a sort of short-term relaxation of some of the issues to get this going, we're supportive of that. But basically, that's their contractual obligation.
okay, thank you.
Any other questions from commissioners right now? Mr. Brown?
And I just have to say, you know, I feel like I need to apologize to the board a little bit because, you know, this question of mandatory is coming up because of the contamination, and it seemed like a pretty simple thing to go to our contracted hauler to say, okay, that we need to implement this, and we just needed to work out the nuts and the bolts. I'm mystified by the response we've gotten. You know, one of the things is the liquidated damages, the waiver of the administrative fees, was told to me by Waste Management that that's non-negotiable for them. That's non-negotiable for me. After what happened in 2015, I can understand their concern about liquidated damages in the agreement, but I'm concerned about it also. So we're here basically with the board making what's a politically challenging decision potentially to go to mandatory. If the rollout of that is botched again, I'd hate to think of what the reaction would be from the public. It would be, the county messed this up again. How can we not do so? For that reason, those liquidated damages would have to be in there. And I should certainly hope we're not talking about any liquidated damages, because as I think Commissioner O'Brien talked about before, it would be a lot easier. The change in 2015 was complex. There was a whole lot of moving parts. We went from 2 haulers. They were covering a new area that was covered by Republic before, going to carted service. It's, from dual stream to single stream, twice a week to once a week, all kinds of changes. So that was a challenging one. This one, by comparison, should be pretty simple. So it boggles my mind that we would that would even be contemplated, that liquidated damages would be a problem, but that has to be a tool that we would have to have in order to ensure that everything happens, because we couldn't, I couldn't put the board in the position of looking at a repeat of 2015. That would just be ridiculous. And the fact that it was a non-negotiable item for them just gave me the reason that apparently this is an avenue that's not available to us to try to address the contamination. So we're going to have to look at other venues, including requiring Waste Management to comply with a contract on contaminated loads, which we haven't been doing prior to this month. So
Himanshu did send a letter out to that effect, that starting August, if we get a contaminated truckload, they're paying the $5,000 for it.
correct. In the agreement, it is Waste Management's responsibility to not pick up contaminated recyclables. We sent a letter that basically said if this was in place in July, the charge would have been X. We're not trying to tell you that we're charging you for July at this time, but going forward, we're going to expect to hold them to the contract. I anticipate we'll still be out there trying to do our part to work collaboratively to do what we can to reduce contamination. But at the end of the day, we're going to have to make sure that Waste Management complies with the franchise agreement.
I got to ask you if I heard you right on this one, Mr. Brown. So we were going to exercise a previously negotiated contract provision, and they came back with the waive administrative charges, trying to unilaterally change the contract, and they said that was non-negotiable?
Correct. I'm as dumbfounded as you, I think.
That's an interesting negotiating position. Okay, well, with that, I'm going to ask if there's anybody in the public who wishes to speak on this issue. Come on up to the podium, name and address for the record, please. Up to the podium, please. So we can, up to the podium, and then name and address for the record.
My name is Fern Grounds, 2375 11th Court Southwest. I get really, really embarrassed when I hear people talk about not mandatory trash pickup, because there's renters, they throw the trash in vacant lots. Himanshu, he came out and he'll pick up some on 14th Street. It was containers, plastic containers they'd thrown out with their garbage. That's also a health hazard. It's not just ugly, it's a health hazard. We go around and we pick up trash that people have thrown there, and we went through there and we've seen one on 10th Street, one on 14th Street, where people have just dumped their garbage because they're renters. With mandatory, then everybody would have to have a trash can. By the way, you speak about price. The lady that's the head, she's a secretary of our HOA. She lives in Lakewood Park. She has 2 pickups a week, and she says cheaper rate than we have. So now that's something to figure out. Whenever they're getting 2, we get 1, and the price is going to be higher, and they don't want to pick up people's garbage that they go right past the house. I do think it's mandatory, not only for looks, but also for health. The Board of Health could go out there and really have a field day condemning people. So my feeling is mandatory has to be for the good of the entire community. It has to be. I don't see any other way around it.
Thank you, ma'am.
Thank you, Fern.
Thank you.
Anyone else in the public wish to speak on this issue? Name and address to the record, please.
Good afternoon, Mr. Chairman, Commissioners, Mr. Brown, Mr. Reingold. For the record, I am Lisa McKnight with Waste Management, Area Public Sector Director. In listening to the discussions around the city of Sebastian and the annexation, everything that was asked of the board is directly relevant to what we're asking of you today from the board and the staff. expectations, accountability, a roadmap, short-term, long-term outcomes, and it was closed by Mr. Brown, slow it down and resolve the issues first. In review of the solid waste staff report, Waste Management agrees with its recommendation to consider mandatory garbage collection at the end of the contract term of 9/30/22. However, we disagree with the statement that we're uncooperative. Although Waste Management submitted several items of consideration, Waste Management and county staff cannot come to agreement on the first item related to the waiver of liquidated damages. The current contract contains only one article, 6.6, which was read, for the provision of universal residential collection service. This provision is limited in content, addressing a proposed universal rate, a change in billing through an ad valorem assessment, and the required delivery of a solid waste cart. The contract lacks clear expectations and deliverables related to the transition. Waste Management received notification last Wednesday, as Mr. Brown indicated, putting Waste Management on notice of future deductions, stating July's example would result in $255,000 in fines, $5,000 each. To put this in perspective, the mandatory recycle revenue received from the county each month is just under $198,000. This deduction is 28% higher than the payment that we receive from the county to provide these services. Making Waste Management responsible for the deficiencies in education and code enforcement is not an accurate representation of the situation. We believe this action from Solid Waste clearly supports and defends our position related to concerns on how Waste Management will be assessed administrative charges during a transition and remaining contract term with ambiguous or silent language. Given your current contamination of 35%, which is very relevant to other programs that have universal service already, we are of the opinion going to universal is not going to have the impact that the county is seeking. One might conclude that the county sees a revenue stream through excessive administrative charges to fund continued education and code enforcement. This is not what the relevant contractual provisions were intended to do. Therefore, we support the recommendation of waiting for a new RFP process to establish the appropriate terms and conditions that align with the collection efforts with the appropriate processing functions. During conversations with Mr. Brown last week, Waste Management requested information related to your current processing agreement, including tonnage reports and a site audit, to determine the exact extent of the contamination in this contract. This was in an effort to help the county and an effort to help your processor. Although current assumptions have been around 35%, we do believe and are of the opinion to the extent that you could jeopardize the future sustainability of your current processor with the continued contamination. We think that exploring certain avenues of the contract in conjunction with conversations with Tropical could help solve the immediate contamination issue. We would need some time to see if those actions might be fruitful. Today's decision by the board, following the recommendation of staff, does not negate our intentions to continue to help the county. We view ourselves as the county's partner and simply need time to develop a mutually agreeable approach. We do understand that there's accountability for tagging. We do have a meeting set up that was originally for yesterday. There was not enough time. It was allocated for 30 minutes. There's a lot of issues at hand that need to be discussed and done correctly. If Waste Management were to go and do an aggressive tag program, the last thing we want to do is discourage your residents from recycling altogether. I think that's the last thing that the board wants to see happen. We are committed to doing this and doing it correctly. And that's what the meeting is for on the 23rd.
Excuse me if I don't break out laughing. I'll just start with one. The Sebastian annexation is not similar. It's different because they don't have a annexation agreement, which would be like a contract. So that is where we are asking for to get these details worked out, put into an annexation agreement, in our case with waste management, we have a contract, and the contract outlines these things that we've been talking about here this afternoon. So one, I don't think they're similar at all. Two, I was on the board when we awarded this franchise. I remember Waste Management coming in here and saying, you know what, we're one of the biggest in the country. We can do this. You know, we're big, we're strong, we're powerful. We can do this. And now you're saying, no, we can't. I find it very offensive that even though the contract says the franchisee is responsible to control contamination, that you managed to turn that around and blame our code enforcement and our solid waste staff. That's unconscionable, I think. I think we've done a lot from education. I mean, we have a person hired specifically for recycling education, and I think they've been doing an awesome job. I see, you know, Sue is now in all the schools recycling, doing things like that. To imply that we failed in that aspect, I'm out of words right now for that. And when you all bid on this, I remember you all really would have preferred to go to Universal. You all kept talking about that. You said, oh, this would be the best way to go. At the time, there wasn't political support on the board to go with mandatory universal. And I feel really offended because, like I said earlier, your staff had told me we would love it if you guys went to mandatory. And I feel I put my neck out a little bit when I brought this up at our budget workshop to recommend to the board that we increase people's taxes, to put this on their tax bill to go to mandatory. And I'm very appreciative that the board supported me on this, but then to have our waste hauler come up with all these excuses and want to materially change the contract, I don't know how I can go back to the people I represent and tell them, you know, I don't want to say the words because they'll be bad words. I don't want to get in trouble, but this is wrong. And Lisa, I don't know where this is coming from. If it's somebody higher up than you and you're just the messenger. Amy and Dina, I can't believe you two really believe this, honestly. We've been working with you guys for almost 4 years now, and what I just heard, that statement that Lisa read, I don't think that's you all. It sure doesn't sound like the people I've been working with. So I don't know where this is coming from, but it's not right. It's not good. I think it puts waste management in a very poor position. And I'm going to leave it at that because I don't want to say something I'm going to regret.
I don't want to say much either, but the comments that you made about our employees trying to implement a program in order to generate revenue streams is so insulting and so offensive that if it was just up to me, and I could pull the contract, I would pull it and never talk with you again. I think, and I don't care when you do it, but you owe our staff an apology for that. And until that comes, I certainly don't want to, I'm not going to talk to you at all. It's so freaking insulting and offensive.
I mean, I've said all I kind of need to say, but, you know, we are sitting here at 66% recycling. We're number 2. We're below our 70, so we do have to do a plan, but we're at number 2. We're above many, many larger counties than us. And that's because we've made the effort and the investment with our partners, of which I was under the assumption Waste Management was one, to educate the public and put programs in place that would help us turn the dial in a real constructive way on recycling. And now we have a contamination issue. And I do not agree with you that universal will make it worse. The reason we have a contamination issue is because people are making a choice to not take their garbage to the proper place. So if you provide them with a proper place to do it, it should take that down because they're going to have 2 carts.
For clarification, I did not say that it would make it worse. It was not going to fix your issue altogether.
I never said it was, nobody ever said it was gonna fix it altogether. But it is a step in the direction of trying to address it. And I think that the position that Waste Management has taken, wherever it's coming from, is unfortunate, because the only thing that it's really done is illustrate to us what this relationship really is about. And it's really not about helping solve the problems that we're having. It appears to be more about trying to get out of a bad contract that you entered into on your own free will, because it does have a signature from a Waste Management representative, I'm assuming. So my guess is that that RFP or that proposal was put in effect to get your foot in the door to Indian River County. You didn't get your foot all the way in the door, so now, because we have an issue that we need to address, we're gonna try to expand that and use it as a reopener, which it's not. So to the extent that you have alluded to all the things that you have, I am of the opinion that our relationship with Waste Management is broken at this point, and I don't know how we move forward. But I find that unfortunate, because I do really enjoy working with our local people. I think they're great people, and I think they do a really good job for you guys, and it's very unfortunate that it has come down to this. But I will stop before I say something I'll regret too.
Well, I'll probably do that.
Okay, good, thanks, Tim, we appreciate you.
When we use the word definition of contamination, I'll tell you what we do at our house when I tell my kids what you can put in the blue bin and what you can't. You get pizza from one place and the box is soiled with oil on the bottom, probably can't recycle that. So what level of contamination is the driver supposed to open the lid and dig through the recycling to figure out what's contaminated, what's not? I don't think that level of it's a general word that's used, and somehow, for both sides, for us and for them, we have to come up with language of what is considered contamination. A bag of Huggies in a bag in a blue bin, clearly contamination, but that's the extreme. How do we clearly define expectations for both sides to figure out what is an agreed upon to contamination? To my kids, they know at the house, if they order pizza from one place, that box won't be recyclable because of the way the pizzas are made. So, and others, they have a liner in the bottom, and you take that out, and then you recycle the box. But that's really getting into the weeds. But at some point, who's going to decide a contaminated load that gets diverted to the landfill that they get a bill for when we have a very brief, we have the word contamination, but it's so loose, what does it cover? How do we fix that in the interim? And secondarily, to me, if you tagged a guy's cart once and you tagged it twice, the third time is when you go take his cart. You don't give him you don't go code enforcement, you just yank his cart, and I don't know when he ever gets a cart back. Maybe when he moves and a new person comes in, they get a cart. But you can't, because some people will be habitual offenders and they will never stop. Or they'll stick it in their neighbor's blue bin when he's not looking. So then that guy gets the rap for the neighbor next door. So to me, you take the bins you tag it twice, third time is removal. There's not a code enforcement, because you're trying to go after the tenant, the problem, but it's the landlord's gonna get the bill, and they'll have to sort it out somehow. And I'll say the one thing that will be controversial.
Oh, good, we're finally getting to it.
All the numbers in the contract are from proposal 3A. Service option 3A is what's in here. What we are asking Waste Management to provide are things that were in option 3B, which were not included in the contract. That's just my simple way of looking at service option 3A matches up with this. But in service option 3A, the options for these other fee structures are in 3B, not in 3A in this document. Seems like it was this based upon the 3A price structure?
Yes, with 6.6 that had, before 2018.
Right.
Kind of like an incentive to try to move to mandatory collection.
Right. So I see why we have the difference of opinions, because 3A we used to fill in the blanks on page, whatever this number is, 34. But the discussion items and some of the things we're looking at doing is from 3B, which are not in here. It is a contract that covers everything in 3A, but we're trying to take portions of 3B and move it up into 3A, and that's where I see a difference of opinion. And I could see why you have two sides at two different of opinion, and it's not gonna get resolved today. But I think giving some, does anybody define contamination in terms of recycling? What is, is milk, leftover milk inside the plastic milk jug that's not been rinsed out considered contaminated? I don't know.
Yes, it is. It's a liquid.
Okay, so
So,
how far do we get into the weeds on the definition of contamination?
so what I've told Waste Management, I told Lisa last week, sent her an email, and I'll say it here today. What we're trying to tackle right now is people throwing their garbage into the recycle bins. That's the crisis at hand. Now, there's all kinds of contamination, from the greasy pizza box to people putting their recyclable cans in a Publix bag, which they're not supposed to do, to, putting a styrofoam cup in there that they think's recyclable and is not. Wish cycling, if you will. That's not our target right now, and what my communications to Waste Management have been is we're telling you, don't pick up the recycle carts that have garbage in them. I'll say in the contract, it says there, to the extent that if there's some stuff in there that they can remove, they cannot pick that up and pick up the rest of it. The immediate goal is to not pick up the bags of garbage in there, which is not to say that we don't need to address those other things. We need to reduce contamination all around. But what we're looking for immediately is to not pick up the carts that have people's garbage in them is the problem at hand right now. I'd say the contract gives us more rights than that, but what I'm wanting to focus on for right now is the garbage being placed improperly in there.
So, Mr. Brown, if I can address that, because that's a big item of why we wanted to get together with staff, with county administrator, with our attorneys, to make sure we're all very clear on the expectations for what is needed for tagging. Because right now, it has been said 5 times already that your residents are putting garbage in their recycle carts, but you're holding us accountable to the tune of $5,000 for every load that we deliver to the landfill. I think that that's unfair. So with that, there's contradictions in the contract when it comes to providing the service that Mr. Brown is asking, because section 11.4.1, all containers shall be completely emptied, and 11.6.1, franchise shall not litter or cause any spillage to occur upon the premises, when Himanshu has asked us to take garbage out and just set it aside on the person's residence. We can't do that by the contract, or we're going to get fined in a different manner. So we're just asking that we have the playbook to make sure that we're tagging and cleaning up the contamination that's taking place in Indian River County the correct way. That is the most important thing that needs to be done. And Commissioner Adams, we fully support being a partner, tagging and doing the right things here in Indian River County. It is not our intentions to not do that. It is our intentions to put the resources available that need to be done to comply with that. But we want to make sure that what we're being asked of the county is exactly what we deliver in the field, to make sure that we do not hurt your recycling program going forward. That is the last thing that we want to do. We want to make sure that there's a good, clean recycle education program that code enforcement and waste management can work together with.
And that would be fine, and that would be wonderful if what you guys have sent to us in your email didn't include a list of 7 other items that you wanted to discuss. If you solely wanted to help us with the contamination and recycling issue that is by nature of the contract your issue as well, then all the other stuff wouldn't have been included. So, I think that's where we're just a little frustrated and concerned, is that we do want to talk about this. We do want to solve the problem, and we do want to take the time to do it effectively. But you're throwing in so much more than just that one issue that it's very difficult for us to feel as if you are acting in good faith.
I can certainly appreciate that. The manner in which we have been assessed liquidated damages since the onset of this program have been very unfortunate, and they have been very unfair. And to go down a path of another transition that sometimes things are out of Waste Management's control. A few items would be truck capital is about a year off schedule. I did have detailed conversations with Himanshu of what's taking place in the market. I do know that there's a contract that starts October 1st that Waste Management is no longer going to be servicing. The new company is coming in. We've already been called to the table to make sure that we have a contingency program in place because that new hauler is not going to get their trucks in time. So that is an issue beyond our control. There was also, Himanshu stated 10,000. We believe there's 17,000. There's a little bit of a gap between how many residents are actually going to need service. So does that take your deployment and implementation from 1 month to maybe 6 weeks? And this is the little bit of detail that we got hung up on the first time around. So it goes back to the very beginning of my conversation, is that it's a playbook, it's expectation, it's accountability, and making sure that whatever is agreed to, and we can't have arbitrary fines just because there is an expectation that's not necessarily relevant. That's where we're going to.
No, I think we're getting off track here a little bit. I think that we ought to just go to, if I understand it right, the county administrator's recommendation was to not pursue mandatory pickup. So I think that there's a lot of negotiations that are necessary, but they're not part of this item. So I think at this point, it might be better to just address the issue before us, have the commission take a vote on it, see which direction we're going, and leave the part of the relationship developing going forward to Waste Management and the Solid Waste Disposal District staff. If that's okay with the commissioners?
Well, I think, well, I agree with what Commissioner Adams just said, that if the issue is how do we want to treat the contamination and recycling, and whether Waste Management should pull the garbage bag out or not, things like that, I think we can work out. All these other things about overflowing commercial containers, radio frequency stuff, all that stuff is not anywhere near associated with whether you pull that bag of garbage out or not, okay? So if Waste Management, if you want to drop all those other things, and like I said, I'm willing to give you some time on the truck thing because I understand those things, and I think that's reasonable. But if you want to drop all these other issues and let's focus on the recycling, then let's do that. So can you tell us now right here that, yeah, all these other things are going to go away and let's work on getting it right on the recycling side, then I still want to move forward with mandatory. So can you tell me we can do that?
The liquidated damages on the conversation that Mr. Brown and I had were on agreement on both ends that neither party can come to terms. It'd be very difficult to move forward without having that accomplished.
Okay.
Okay, with that, Commissioner Zork.
So back on the, not to pound the contamination thing to death, so let's say you got a really creative guy, puts all his garbage on the bottom, puts 3 pizza boxes
Oh,
in.
come on, Commissioner. I mean,
How do you?
we're not going to address that issue
Okay.
today.
No, but even if they inspect every lid 100% of the time, every day, does not mean you will not have contaminated load.
Nobody's saying anything like that, and this problem isn't here because of 1 or 5 or 10% contamination. The contamination jumped from some 20 to 30%. That's what triggered it. You can always come up with counterfactual ideas to deny anything, but we're not living in an alternative universe. So, Chair will entertain a motion, one way or the other, to either move forward with mandatory or to keep the existing system.
I make a motion that we keep the existing system.
Second, any other discussion? Anybody else from the public wish to comment on this? All in favor? Aye.
Aye.
Any opposed? Matter passes 4-0. Commissioner Flesher absent. Thank you. Move on to change order number 5 to Thalbid. Mr. Burke.
Yes, we are requesting change order number 5 to Tally. That is currently expanding our landfill and closing off the other portion of the landfill. We provided some backup with respect to some of the previous change orders. This one does have an amount of $530,761.05 that would be taken out of contingency. The board may recall that there was a large contingency set aside for some unforeseens. We've had some roadway, we've had some swale work that was needed, and certainly we're asking for approval that looks at the $530,000. Solid Waste Disposal staff recommends that its board approve and authorize the chairman to execute change order number 5 to Tally Construction, approving the extension and contract time for milestone 1, 2, and final completion of 68 days. We do have CDM Smith that has gone over and verified, not given all of the days that have been asked for, certainly to Tally Construction for the segment 3 cell 2 expansion, as well as segment 2 partial closure and landfill gas system expansion project. There is an attached CDM letter, Smith letter of recommendation that we've included in the backup, as well as some of the information with respect to change order number 5. And if there's any specific questions on the construction for Tally and or CDM Smith, we are available for any questions the board may have.
Move staff recommendation.
I'll second it. Any discussion? Anybody from the public wish to comment on this item? Do you wish to comment on this bid?
I would like to ask, is this going to come before the commission again, the mandatory pickup?
Probably not in the very near future. Sometime in the future it may, but not right now.
That's a loss for our community. It's a loss.
Yes, ma'am. Pardon? Anybody have any other questions or comments? All in favor?
Aye.
Any opposed? Passes 4-0. Commissioner Fletcher absent.
Want to adjourn us?
I want to enjoy the quiet for a minute. Calm down before I read the changes.
Just wish you a safe and happy trip
Thank you very much.
coming up.